Good afternoon, everybody. Uh, Welcome to the latest of HK45's Fireside Chats for 2024. So thank you very much for joining us today. My name is Praderi Deepschlag. I'm a counsel at Clyde & Co in Hong Kong, and I'm one of the co-chairs of HK45 along with Dong Long and Kitty Zhang. If you are new to HK45, we are a group for young and the not so young arbitration practitioners in Asia and globally, in fact. Our aim with HK45 is to provide a platform for members to learn from each other and to learn from leading figures in arbitration. We run a multitude of events in order to achieve that, such as this virtual one. We run large in-person events. We get to hear from luminaries in the profession and all the way down to very small group dinners with judges and arbitrators. We also do a multitude of social events, such as our junks, that are coming up over Arbitration Week and Pub Quiz and our Christmas cocktails. Now, I don't know how you found out about this event, but if you didn't receive our email, that means you are not a member of HK45. And we are finding that a lot of people are now reliant on LinkedIn. And we would suggest that you don't rely purely on LinkedIn to find out about these. Membership is free. It's open to everyone. I suggest you sign up after this session. So on to today. HK45's Fireside Chats are one of our flagship initiatives. We invite speakers to share their career highlights, some personal stories, some lessons that they've learned, and we hope that you'll find something encouraging and some motivation there, and perhaps walk away with a few ideas for your own careers. I should also mention at the outset that we record these sessions. So if you have to drop off at any point, the recording is available on YouTube. It should be up next week. Now, with that, I am delighted to introduce today's guest, the Right Honourable Dame Elizabeth Gloster, DBE PC. I'm also delighted that I do not need to use her full title, as Liz has agreed that we can call her Liz for today's purposes. So Liz's career began with her education at Rodin School, followed by Cambridge University. She was called to the bar at the Inner Temple in 1971, where she specialised in corporate matters, insurance, reinsurance, financial markets, energy, and insolvency and reconstruction cases. Now, she took silk in 1989 and was appointed Judge of the Courts of Appeal of Jersey and Guernsey in 1993. A decade later, in 2004, she made history as the first woman to be appointed as a High Court judge at the Queen's Bench. In 2010 to 2012, she led the Commercial Court during the period of significant change, moving to the Rolls Building. And in 2013, she was then appointed Lady Justice of the Court of Appeal, a Privy Councillor, and later served as Vice President of the Civil Division from 2016. Throughout her career, Dame Elizabeth, Liz has been involved in numerous high-profile cases. As counsel, she handled the insolvencies of major corporations, household names such as Enron, Marconi, Barings Bank, and participated in significant arbitrations involving oil and gas in Russia, the US, and elsewhere. As a judge, she presided over landmark cases, including JP Morgan and Springwell Navigation, Berezovsky and Abramovich, and some of the fallout from the Lehman Brothers insolvency, and of course the LIBOR fixing scandal that we heard so much about maybe was that 10 years ago. In 2018, Dame Elizabeth retired from the Court of Appeal to practice as an arbitrator. Today, she continues to contribute to the legal field as a patron of the London branch of CIR, a freeman of the Worshipful Company of Arbitrators, a judge of the Abu Dhabi Global Markets Court, a justice of the Court of Appeal of Bermuda, a member of the arbitration panel of the EU-UK Withdrawal Agreement, and in 2021, because all of that wasn't enough, she was appointed to the ICC International Court of Arbitration. And last year, she became Deputy Chair of the Takeover Appeal Board. So despite all of these commitments, astonishingly, Liz agreed to speak with us today, and we are incredibly grateful for her presence. Now, the last thing that I have to do before we kick off is introduce your hosts. We have Lillian Lee, who's an associate at Quinn Emanuel in Hong Kong, and we have Cecilia Choi, who's an associate at Linklaters in Hong Kong. And most importantly, I'm pleased to say they're both members of the HK45 committee. And together with Dong Long, they've helped to put this session together. So with thanks to them, I shall pass the floor to you.
Thank you, Pri. Thank you for taking up your valuable time to meet with us today, Liz. We're really honored to have you. And can I also express our thanks to the audience for joining us today, notwithstanding that there's a typhoon looming just around the corner in Hong Kong. So why don't we dive right in? We'll start with some easy questions first. We usually go right back to the very beginning. So can I ask, Liz, why did you decide to read law?
Thank you very much, all of you, for inviting me here. Can I just correct one thing, which I should have done earlier when I was sent the text, which Pri said, which I wasn't the first woman to be appointed as a High Court judge of the Queen's Bench. I was the first woman to be appointed to the Commercial Court as a Queen's Bench judge. And if first count, that counted for me anyway. Why did I decide to read law? Truthful answer, I was too argumentative at the dinner table and thought it might be a good idea to use that to some good effect. But actually the practical reason was, in those days, not today, it was much easier to get in to read law as a woman than it was to get in to read English, which every girl seemed to want to do back in the day, a long time ago. So that's why I read law at Cambridge.
If you haven't gone into law, given you're argumentative, as you say, personality, what do you think you would have done?
Oh, I'd have loved to have been an entrepreneur, a businessman. My father was a businessman. He hadn't been to university. And I'd have loved to have gone into his business. But with the attitudes of the day, he said, oh, no, you've got to have a profession. I'm not having a woman in my business. So there you go. I'd have loved to have been an entrepreneur.
But you chose a more academic route, and we understand you were called to the bar in 1971. Would you be happy to tell us a little bit about how you secured pupillage and tenancy as well as a lady in the 70s?
Well, it was a nightmare. Getting pupillage, unlike today, was no problem at all because we had to pay £50 for the privilege. So pupil masters were, as they were then called, were delighted to have as many pupils as possible. Getting a tenancy was an absolute nightmare. I did 4 pupillages before I got a tenancy. Very, very difficult as a woman in commercial work. I ended up doing a pupillage in matrimonial and civil chambers. I really liked the civil side. And when, after a year of squatting there with a nice little practice of my own, and the clerks delighted, I said to my pupil master, can I be a tenant here, please? I've got a nice little practice going. Oh, no, he said very loftily. We don't have women in these chambers. So I said, well, why on earth not? Oh, well, the wives of members of chambers wouldn't like it. So I went home and cried and cried and cried. But luckily, I then got a pupillage with a view, as it was then called, to a tenancy in Chancery Chambers because, wait for it, they were desperate to have a woman because they thought it would improve their profile. So a huge difficulty in getting a tenancy, but I got there in the end.
Well, that's amazing. And so that's how you, so is that one of the reasons you got into the chancery work then?
Oh yeah, I did a company pupillage to begin with because company law was my best thing at university, and my tutor gave me a reference, an entree to a set of chambers, as they did in those days. So I didn't get taken on there as a tenant, but I did get a very good grounding in chancery and corporate work, which has stood me in good stead.
And I think we have a lot of younger practitioners as well who are sort of eager advocates as well. Could you please give us some insights or a little story on how your first time cross-examining a witness felt and how you prepared for it?
Oh, well, it was horrific. I was a pupil at the time. And in those days, if you were a woman with a baby and the father wasn't paying, you had to take him to the magistrate's court. And I had to cross-examine some reluctant man who was refusing to acknowledge that he was the father of the child and refusing to acknowledge that he had to pay for the baby, about whether or not he'd had sex on that particular evening with the girl in question. It was excruciatingly embarrassing for everybody. But actually, I did get a result. How did I go about it? I constructed a meticulous chronology about what had happened on the days in question, leading up to the act that that ended with the birth, happily, with the birth of this child. And after, I suspect, a very tortuous cross-examination by me, the man finally admitted that yes, indeed, he'd had spent a lovely time with my client, and he was indeed the father of the baby. And we then got on to what he was earning, and I was obviously much better at cross-examining him about that, because we ended up with him having to pay something. So that was triumphant. And I really enjoyed it, although I did find the whole thing very embarrassing indeed when one kicks off. But I learned a lot from that.
Well, it doesn't sound horrific. It sounds very successful. You got what you needed.
Yeah, so Liz, I think a bit of questions perhaps on your life as a judge. So as you've mentioned, over your distinguished career, you've held many significant positions, including being the first female judge appointed as the head of the commercial court in England. And as Free has mentioned in his introduction, during your time as a judge, you presided over a truly incredible number of cases. In the process of preparing for today's discussion, I put your name in the English case search database just to see what are the type of range of cases that you've done. And I'm totally dazzled by the number of landmark commercial and financial market cases that you have written a judgment on. So just as an example, every heartless law student in Hong Kong, as you've put in Patel, would be asked to read JPM and Springwell Navigation as part of the prescribed reading for the position of what is an actionable misrepresentation. So it is a truly incredible legacy that you've left behind at the bench. But having said all these, you've obviously had a very successful career as a barrister. What actually influenced your decision to join the bench?
Well, I was asked on a couple of occasions, some years before I finally accepted the appointment. I think from a practical point of view, I'd paid off my mortgage and educated my children, so my accountant wasn't being so difficult. But principally, I think it was because, having been a QC as I then was, you get to a stage in your life where you're incredibly well paid, which was super, but there's a huge amount of pressure on you to perform well. And the better you do, the more the pressure mounts on you. And you suddenly turn around at some stage in your life and you think, actually, rather than being paid by people to come up with an argument, I'd rather intellectually have the fun of getting to the right answer. And I know one of the judges I respected said to me, he'd been an incredibly successful silk at the bar. He said, "You will always regret it if you don't go on the High Court bench." And when I got the tap on the shoulder with the possibility of going to the commercial court, I thought, hang on, this is a life-changing moment. I must decide. And I want to come, I want to be in a position where, instead of appearing in front of some judge who's going to get it wrong, I am the judge who's going to get it right or wrong. And I never regretted it, because intellectually it's really satisfying, or it was really satifying.
Well, speaking of pressure, you obviously, and Cecilia's alluded to this, you've faced, high profile positions and you've overcome them. You've also presided over extremely public cases, high stakes claims like the Abramovich case, which I think in the UK has been hailed as one of the largest civil cases in British history. So at the time, how did you handle the pressure and publicity?
I've got quite sort of broad shoulders, speaking metaphorically. I really enjoyed the Abramovich and Berezovsky case. I'm not sure whether it was the largest civil case. It might have been at the time. I'm not sure it is anymore. But certainly, I enjoyed the ability to control a courtroom. And that's not necessarily a legal skill, it's a communications skill. And I learned a lot having to do that. And I had to go into the case knowing that there'd be a lot of press attention, that there'd be comments about whether I'd be scared by the idea that Jonathan Sumption QC, as he then was appearing in front of me because he was on his way, as everybody knew, because it was public, to the Supreme Court. I thought there was going to be a challenge to that. But I thrived on the challenge, I think. Insights on how I dealt with the pressure. I kept my mouth shut. I didn't let anybody know how I was thinking. That was critically important. I left counsel to make the submissions. It wasn't a case in which one had to interfere, or one should have interfered as a judge to say, oh, surely the view on this bit of Russian law is X, Y, Z. It wasn't a case for arrogant judicial intervention. But I think principally, I learnt the usefulness of having computerized documents. I think it was the first case in which all the documents were available electronically, in which, with the exception of, I think, the submissions and the transcripts, I worked electronically. We're talking back in 2012, I suppose it was. And that was, oh no, was it? Yeah, I think 2011, 2012. That was an incredible boon to me, the ability to see everything on a screen. And that is actually one of the reasons I cope with it.
I must say you were very advanced, because the majority of our cases in Hong Kong are still held through paper filing with pages and pages of bundles in court. So certainly quite a bit for us to learn from in Hong Kong.
Well, I'm not sure I could cross-examine. If I was back at the bar, I'm not sure I could cross-examine without printed out copies of the documents I was looking at and yellow stickers. But I see really good KCs now and senior counsel being able to do that. And that's a skill, luckily, which I've not had to learn, but I take my hats off to them who can do it. But certainly you've got to be able to work electronically, I think, these days.
Well, moving away from the public arena, though still a high stakes arena that's edging towards electronic only documents, we understand you've obviously moved from the bench to arbitration. And since becoming a full-time arbitrator, one question is, has your approach in thinking or listening to arguments or submissions changed in any way?
Yes, I think I've become more patient, because one's very conscious when one's doing arbitration that parties have chosen this way to dispute, to resolve their disputes, that they don't want the formality of the courtroom or the idea that they're one in a queue of lots of other cases. And I think that's a good thing. And I think that, so my approach is, have I become softer? I don't think that's quite right, but I've become more, I think more tolerant, actually. I think I mean, I think robust case management is absolutely essential in arbitration, otherwise it can meander on. But I like the informality of the arbitration setting. Sometimes it can be too informal, and counsel think they have an indulgence from the tribunal to bang on and deal with things or address points that aren't actually relevant. But I think that is the difference. I mean, my courtroom was never that formal, other than obviously in cases like Berezovsky or in the Court of Appeal, where one had to preserve a certain amount of formality. But I think the arbitration context is preferable, actually, because it isn't so formal.
Would you say the informality is what you enjoy more about arbitration and being an arbitrator as compared to being a judge? Are there any other things that would suggest to you that you actually would prefer arbitration more?
I think they're different experiences. I love being a judge. It was terrific, and you got to decide public issues of public importance, and I very much enjoy that. I very much enjoy arbitration. I wouldn't want to say which I enjoyed most, because it depends on which day of the week it is. But I think what I do enjoy about arbitration is I enjoy sitting with other people, with my co-arbitrators, from different, often from different legal professional backgrounds. I enjoy, I mean, I sit with people not just from civil law jurisdictions, but from different jurisdictions all over the world, including the PRC, the Middle East, wherever. It's very interesting. I also very much enjoy, which I didn't get in litigation when I was a judge, listening to very clever and experienced counsel from different professional heritages, backgrounds. I mean, that's just wonderful. I think my vision of the dispute resolution world has certainly broadened since being an arbitrator. And that's really interesting, actually.
You mentioned that you are a strong believer of robust case management. So perhaps to expand on how you're able to bring your perspective from the bench into arbitration. Now, as an arbitrator, do you find yourself at times suffer from the influence of due process paranoia, which, for the benefit of the audience, is the perceived threat among some arbitrators that taking decisive actions in relation to the management of the case might lead to the court refusing to enforce an award. So how do you think your experience as a judge has helped you navigate these concerns?
I think it has helped me, because it brings an approach that you can't, that it is not in the interests of justice or in the interests of the parties to let a dispute meander on, to roll on. I find that there is a tendency in arbitration to assume that everything is going to take a very long time indeed. So I think it's important that that one shouldn't be over concerned by parties saying, which they often do, or counsel saying, which they often do, oh, well, if you don't give me another 3 weeks, that'll be unfair, and there won't have been equality of arms, etc., etc. And I think one has to be quite obviously balanced, and it all depends on the circumstances, but one should be brave enough not to succumb to threats where they're not warranted. Obviously, if time is required, if documents are required to make the process fair, then whatever the costs in time, one will need to provide for that. But I do think that some of my colleagues may be overly concerned by the threat that at the end of the day, there will be a challenge on the basis of unfair process. And I mean, obviously one has to listen, but I think one does need to get on with deciding things.
That's a very sensible approach. I think the other question that people have would be over appointment of arbitrators. And as we all know, the arbitration community is very small, and in certain sectors such as shipping law or insurance law, they're even smaller. So it is always a tough balance between finding the trusted and reliable arbitrator and avoiding the appearance of bias. And I believe most people in the industry recognize that, and they recognize the difficulty to find that balance. But I understand that recently you've come under some criticism for repeat nominations by Freshfields. Is this something that you have a response on or comment about?
Well, obviously I have to be very careful because I'm the subject of a reported decision where I was held, or the fact that I'd had accepted and not sufficiently disclosed in time a particular appointment, actually not as an arbitrator, I think, but as something, as an expert, was said to give rise to implied bias. I mean, as an arbitrator, and particularly as an arbitrator who's been a judge, I just don't ever think I'm biased. So it's, you know, one never does think one's biased or there's any question of implied bias. And one just has to have the broad enough shoulders to take the criticism. The trouble is, I suppose, that I still have the instincts of a barrister, that one takes on everything, and maybe attitudes to conflict have strengthened or got much more critical, if you like, over the years. And I think one just has to live with that. And if one's conflicts data aren't sufficiently good to deal with the job, or one in the, you know, one just doesn't realize one hasn't disclosed something that one should. I mean, question mark, should I be disclosing to somebody that I'm appearing on this panel? You know, it's a very different world today, because I suppose the tradition on the English bench certainly is, well, one in the commercial environment, the commercial bar, the shipping bar, the insurance bar, one's acted for these people as counsel all over the years. No, of course one isn't biased. One just gets on with the job. But the arbitration world, I think, is stricter, and has become recently stricter in its approach. And I think one just has to accept that.
And how do you think your experience as a judge specifically has helped you, I suppose, shoulder these particular concerns? Do you think that, for example, being a judge has made you more accepting in a way you can see the situation more objectively?
Yes, I think so. I mean, in Berezovsky, there are all kinds of conflict issues. Will she be suborned by the fact that Sumption is about to be a Supreme Court judge? Is she conflicted because an ex-pupil and someone else in her chambers are appearing for Berezovsky? I disclosed the fact that my stepson had appeared at an earlier stage for Abramovich, but after, and at the time, Berezovsky didn't complain, and I raised it with counsel, they didn't complain. Everybody knew everything, but after Berezovsky lost the case, there was a press battle against me on the basis that I shouldn't have accepted it, shouldn't have accepted the appointment as the judge. So, you know, I suppose my experience as a judge has indeed taught me that one just has to deal with these things and cope with them. You know, the trouble, as you say, in a small industry, which we are, everybody does know everybody else.
Well, conflict issues are often something I feel
Yeah,
more senior
exactly.
members of the legal profession have to shoulder. and
Yeah.
cope with, certainly. But if we look at the other end, so the younger members, having experienced, lived and breathed as a student, a barrister, judge, and arbitrator, what sort of advice would you give younger lawyers, and what would you think they should focus more on in a context of an arbitration as opposed to litigation?
Okay, I think I feel really humble at the idea that my advice as somebody out at the end of my career is actually going to influence anybody. But as you've asked me, I think the critical thing as counsel in an arbitration is to communicate with clarity and succinctness. You've got to get your message over using the minimum amount of pages. You've got to have your clear points. Length is not necessarily better. And I think clarity, conciseness, that's what counts as an advocate. And I would really underline that. And it was only, I think, when I'd been sitting as a judge and now indeed again as an arbitrator, that I realized how much clarity, conciseness, and also the way you construct your argument matters. The second bit of advice I'd give, for what it's worth, is that if you want to get on in arbitration, I think it's very important that you try and get appointments as tribunal secretaries, because that's where you learn. And the third thing I would say is, do get your partners or the leader of the team to get you to argue a point or to conduct a cross-examination to give you a bit of practice. Now, it can be quite irritating if you're sitting in a tribunal that you've got about 10 people lining up to cross-examine the postman or whoever, the courier, But I think it's really important that you get a chance to actually appear in a tribunal and say something. And I think young people should be given that opportunity. And I think they should ask for that. You never, you don't get if you don't ask. And that would be my advice.
That's very good advice. It's true. You must ask. Well, still on this topic, and other than very lengthy submissions, is there anything that you would like to see less of from counsel in arbitration? And doesn't have to be limited to the younger counsel, could be senior counsel as well.
Okay. I'd like to see less correspondence between the two firms of legal representatives. I mean, there are pages and pages of stuff, and I don't know whether they think that the arbitrators are going to be reading them all as they come in. Maybe they are, maybe they're not, but there's far too much, I think, litigation or arbitration in correspondence. What matters is what you say in the arbitration room. So that would be one, I suppose, suggestion. The other suggestion is when you're doing your memorials or your pleadings, and this goes back to what I said previously, it's incredibly important that you focus on what actually matters in terms of presenting your case, rather on allegations about how appallingly badly the other side has behaved. I mean, sometimes, obviously, the other side does behave badly, and then you should get the arbitrators to deal with it. But where they haven't, don't make a mountain out of a molehill in arbitration. It's very irritating, or it can be very irritating.
Your advice about not writing long letters certainly will help Lily and myself to get off work a bit earlier rather than battling over midnight correspondence and emails.
I know. I mean, I used to do it as counsel, and in the end, you feel like saying, well, you know, see you in the courtroom, see you in the arbitration chamber.
Yes, so I guess my next question is transitioning from being a judge to an arbitrator, where you now have more autonomy to accept or decline appointments. I mean, this must introduce new dynamics because as a judge, presumably you can't really choose what comes into your dock. How do you balance the enthusiasm for taking on another new and exciting arbitration appointment with the necessary requirements to maintain a healthy work boundaries, as well as to ensure that your decisions remain well considered and that you actually have time to consider the case thoroughly? What are your strategies and criteria in managing that balance?
Oh, I think this is the most difficult question so far. Actually, as a judge, one could choose. I mean, in the commercial court, you could choose what you could do pretty, not the particular cases, but you could choose how to organize your life. As an arbitrator, it's very difficult. Because obviously, as you say, has enthusiasm for taking on more work because it's so interesting, it's so exciting to get a new case. It's like being back at the bar, the thrill of the new case that comes in, which sounds slightly pathetic, actually, but one does have an enthusiasm if you're self-employed and somebody has chosen you to be in a case. How do I cope with that? I'll get on to work-life balance in a moment, but how do I cope with that? By having very efficient clerks who keep a very good diary for me and who are always prompting me about what I should be doing and what I haven't done that I should have done. But it is very difficult with I mean, we all know this, maintenance of diary and deadlines are incredibly important. How do I cope with work-life balance? The answer is there is no such thing, if you're a lawyer, as work-life balance. And advice to young people, dream on, you'll never have it. Also, clients don't care about your work-life balance, although they might pretend that they do. They want their document produced tomorrow, even though they're the other end of the world and are ahead of you in time or behind you in time. They don't care about whether or not you've got to go to your son's rugger match or, you know, your daughter's hockey match. So I don't think I've ever done work-life balance well. The answer is delegation, delegation, delegation.
Yeah, so it's more work-life integration and finding a way to make it work rather than trying to balance things, which ultimately it's just impossible, right?
It is possible, but I mean, you just have to be very organized. I mean, don't go and spend time queuing at the nail bar. Make sure your manicurist comes to your home. I mean, that's a silly example, but all these sort of things, you know, make a difference. Make sure that you're not doing things that somebody else can do better. I mean, that goes for work as well. You know, get a junior to do a bit of work or a tribunal secretary to pull together the dates of all the procedural applications. Don't spend time doing that yourself.
Yeah, I guess for my next question, you've more or less answered already, but just coming from the perspective, because I know, Liz, you're also a mother yourself. You've gone through the joy and tears and challenges of motherhood whilst developing a very successful legal career. If you were to give women advice on striving to get that right balance between their career ambitions and family lives, what would be your advice other than delegation?
It is, I think, how do you prioritize things? And that's incredibly important. I mean, I don't think my son, who's now in his 40s, will ever forgive me for not turning up for his most important rugger match when he was playing in the first team. And he'll trot it out from time to time. But that doesn't mean you're a bad mother. And I think I think my advice is, how do you cope with it? Make time for yourself. Make time to, I don't know, it all sounds so superficial and silly, but, you know, make time to ensure that you're enjoying yourself, that you're going to the hairdressers, that you're buying clothes or doing what, you know, whatever you want to do, riding horses, whatever it is, you know, playing tennis, whatever you want to do, make sure you've got time for you. And that you actually enjoying what you're doing. But because if you're not enjoying working, you know, 26 hours a day, then don't do it. But you have got to choose for yourself, because people are so different. And women, particularly in their approach to family, are very, very different. And I think it would be presumptuous of me to say, you know, learn from my life, look where I've got. I think that's appalling. I think it's, I mean, it is very difficult to cope with a family, as well as, you know, having a career. But children are, you know, selfish little devils. At the end of the day, they don't mind, as long as, you know, they get what they want in the end. And I think certainly, I mean, I would say this, wouldn't I? I don't think my children ever resented the fact that I had a career.
Well, and you've had an incredibly illustrious career, you know, judging, of course, by all the positions you've held, everything that you've achieved. But, you know, here's a question. Many lawyers do fear being wrong. There's a fear of failure often, and that often that fear can pull us back. Have you ever felt that fear of failure? And if so, how did you overcome it?
I've felt fear of failure all throughout my career. And I mean, losing a case in the blare of publicity, in the gaze of the legal world, is just so humiliating and so awful. And you just have to pick yourself up and go on to do the next case the next day. Then, as a judge, when the wretched Court of Appeal overturned your decision, they hadn't seen the witnesses. Had they got it right? No, of course they hadn't got it right. They'd got it wrong. And then in the Court of Appeal, when, you know, one wrote a dissenting judgment, and the Supreme Court didn't even give permission to appeal based on my dissenting judgment. As a lawyer, you're always failing, and you have to, well, maybe not always failing, hopefully sometimes you get it right, but you've always got to appreciate that someone will take a different view. And if you can't kind of work in that kitchen, then you better not be in it. You just got to cope with losing out sometime. But I mean, we've all got to learn that lesson, and it doesn't just apply to the law.
Well, thank you for humanizing that for us. I think we can all relate. But last question, because I think we're just on time, and this is tradition for HK Fireside Talks. We always ask sort of an inane question at the very end, but very innocent. So could you please tell us your favorite place or venue to arbitrate other than the HKIC or Hong Kong?
Other
than, because of course it's going to be the HKIC or Hong Kong, but other than.
Well, I've got to, oh, that's so unfair. I've got to say Hong Kong. I've been here, you know, last December when my husband and I had a wonderful time, and then in July. I mean, it's a lovely place, and the view out of the building is fantastic. Where do I quite like New York, actually. I mean, I'm not allowed to say London, obviously, which is fabulous. But I like New York because it's buzzy and you can go and see shows in the evening. I've never ever arbitrated in South America, and I'd love to go there. There are lots of places. I mean, you know, be an arbitrator and travel the world, but but certainly I'd like to go and arbitrate in South America because I'd love to go to South America. But there you go. I would say probably New York.
But we'll keep
After.
South America in mind when we're thinking about venues.
Absolutely. There's a plug.
Thank you, Liz. Thank you for your sharing today of your experience both as a practitioner, a judge, and now an arbitrator. So I think we still have around 13 minutes in which we will invite questions. There's a Q&A box at the bottom of the Zoom chat. So if you have any questions that you want to ask Liz, this is the opportunity.
This is the embarrassing moment where there are no questions at all. Or maybe I can't see the questions.
Yes, the questions are with us. Okay, so we've got a question, which is, do you have any interesting war stories in arbitration within the confines of confidentiality? How about the most egregious logistical mishaps?
Oh goodness, this is difficult. I had one war story which I think I can share without naming names, and it's only happened to me once. And it's not a logistical mishap, but I think the most concerning thing that ever happened to me in an arbitration was when the chair and I realized that our co-arbitrator was sharing our deliberations and what we'd said in Zoom calls to each other and in emails with his party appointors. And that was the only time when I've had to have a call with my chairman to discuss how we were to cope with that. And it was very difficult. And the chairman, who again I won't name, dealt with it absolutely brilliantly. And the co-arbitrator simply didn't believe in or didn't respect or said it didn't apply under the relevant law under which the co-arbitrator he was appointed. So we just had to assume that everything we said was being reported back. The co-arbitrator wrote a dissenting ruling on every single ruling we gave. And it was very, very difficult. I don't have an arbitration story about an egregious logistical mishap. I'll think of one for next time I have to do one of these talks, but I haven't got one at the moment.
Any difficulties in making logistical arrangements during the COVID period when all hearings had to be virtual and you had to adapt to it?
No, I didn't find it difficult at all to cope with. And maybe it was just the nature of the cases I was doing. But cross-examination of witnesses on screen was actually incredibly revealing, because if there was a good camera, and I always made the camera go up close to the witness so he wasn't at the end of a long conference room, you could judge his credibility insofar as one can ever judge credibility of a witness from how he's giving his evidence very well. So no, I do find it can be frustrating when I must be very careful here, when sometimes people, and in particular arbitrators, are hopeless with the IT and haven't bothered to go and practice. you know, because we usually have a test hearing. And again, if witnesses don't bother and have a bad, you know, insist on giving evidence remotely, and then sort of a bad with the IT, or are difficult about it all, I can find that quite irritating.
Well, speaking of mishaps, here's a question from the audience. Do you agree that a good case can be lost because of poor bundling?
Oh dear, I don't want to be too revealing. Yeah. I'm a real stickler for good bundles. I mean, in the old paper days, when the bundles were badly presented, I used to get furious as a judge and as a barrister. I don't think a good case would be lost on bad bundling, but my goodness, it does make life so much easier if the bundling and the electronic bundling is good. And I think one of my biggest, I mean, if I can use this as a sounding board, one of my biggest problems is when you have electronic bundling and, okay, the index will tell you what the R337 actually is. But when you go to R337 in your saved files, there's no narrative at all. And that's really difficult sometimes. It's fine if you've got a hyperlinked, oh, this is all very technical. If you've got a hyperlinked index to the bundles, that is fantastic because you can get there immediately. If you haven't got a hyperlinked index, it can sometimes be really difficult. So I'm very influenced by good technology, and okay, I won't make a party lose a case, but it certainly makes it much easier to take on board their submissions if the bundling is good.
I saw some arbitrators actually put down the requirement for hyperlink bundles in PO1. So maybe that's the way to go about it next time.
I mean, we've all got terribly spoiled with all these really good systems. And we've all got a bit demanding. And there's a huge cost. I mean, I appreciate that for hyperlinking and keeping the platforms going afterwards. And of course, then I mean, one of the great things is having hyperlinking to the documents in the live transcripts. And you don't get that, or I haven't seen that, maybe it does exist, when you get transcripts delivered up at, you know, regularly. You get it when it's live, but not when it's not live. And I miss that. But maybe we've all just got a bit lazy.
Yeah, so actually on IT, we have a question from the audience to ask, do you have any thoughts on whether AI will play a role in arbitration in the future?
Oh, I'm sure it will. I mean, the interesting question is to what extent? If you try and do submissions on a case, I mean, I've had this demonstrated to me. I'm not confident that I've seen any evidence that submissions can be successfully done in the type of complex arbitrations I do by AI. I mean, a friend of mine, Professor Richard Susskind, is always saying, oh, it's just down the track and we won't need to have barristers and solicitors and counsel because, you know, AI is going to be able to do it all. I don't think, from what I've seen so far, that, you know, we're all going to go home and AI will produce the submissions and produce the answer in arbitration. So I think certainly we're all right for the moment. But I don't know, I'd be interested in your experience.
So my firm actually has been quite a big advocate on AI and how to integrate it with client demand. So what we have is we have an inbuilt systemed IT bot, which you can actually float ideas to. You can potentially ask the IT bot to help you draft an email, and that's incredibly efficient. I would say rather scandalously that sometimes it's better than the work done by some of my trainees. So that to me is quite scary, but these are the options and available from that are made available from the AI bot, and I guess we just need to live with it and see how we can elevate with the assistance of these tools.
Yeah, I certainly don't think we should reject it. I mean, if, for example, AI could produce the procedural bit of an award, that would be wonderful. The trouble is one's never got time to test it. But I mean, it's very interesting. I'm sure there are lots of boring tasks that we all have to do at whatever stage we are in our careers will be assisted or can be assisted by AI. And it'll be very interesting. I mean, we've got to live with it. We've got to learn to deal with it, and we've got to use it to our advantage. The question is, to what extent can we trust it? So I'm open to the idea. I mean, if it replaces me, it replaces me. Hey.
Well, here's another one that seems quite interesting. Barristers sometimes act as prosecutors for the Crown, which must be a unique experience. And could you tell us about the Guinness prosecution?
Goodness, that's back in the day. I was a junior when I was retained, and to act as a barrister for the prosecution. I was retained along with John Chadwick, QC, who was leading for the prosecution, because he and I obviously knew about the corporate aspect, and we knew about Section 151 of the Companies Act, which it then, as it then was, which dealt with illegal reduction of capital and illegal support for the purchase of a company's own shares. In other words, the company, Guinness, giving illegal support. And that was why we were brought in. But of course, at the end of the day, the judge decided that issues revolving around company law provisions against illegal financial assistance in the purchase of a company's own shares was far too complex to put before the jury. But that didn't seem to matter. It was all to do with false accounting, actually. And it was absolutely fascinating as a corporate lawyer who'd, I mean, I'd only done crime when I was a pupil in one of my many sets of chambers as a pupil. So I didn't know much about it, but it was a really, really interesting experience. And speaking to a jury is a real test of an advocate's communication skills. And I have a lot of admiration for criminal barristers who can twist a jury in the palm of their hand. So I thoroughly enjoyed it, and it certainly taught me to write economic prose.
It was a good bit of variety at the beginning of one's career, I guess.
Yeah.
So I think we have time for 2 more questions. The next one I have here is, do you think arbitration can help to preserve and maintain peace via dispute resolution process given today's geopolitical climate between US, Russia, and China? So the West and the rest.
Oh, do you know, this is such an interesting question. Of course it should. Of course there should be arbitration of all these huge issues, Russia and Ukraine, Israel and Hamas. But it sounds sort of arrogant to suggest it. And these conflicts are so localized, emotional, political. It's almost impossible to say, as we see, sit down and let's arbitrate. But of course, in a civilized world, that is what would happen. And I mean, we know from history that there have been arbitrations for many years about rights over the seabed and things like that. The trouble is, when it gets into war and death and murder, it all becomes almost too ridden by conflict and embedded attitudes for arbitration to succeed. But if only, if only.
Well, I think we have, Cecilia, you said we have time for one last question, right? So
Yes.
let's make it the shortest one then. Apologies to the others. What is your favorite food in Hong Kong when you come and visit us on?
Oh goodness, I just love the food in Hong Kong. I think I mean, I don't know whether this is particularly a Hong Kong dish, but I just, oh goodness, I love scallops in black bean sauce. Is that Hong Kong? I don't know whether it is or not, but that's what I love. It certainly was on the menu when I was last there.
It's in one of the seafood restaurants.
Yeah, I think so. Yeah, in one of the seafood restaurants. But I love Chinese food, as indeed the world does.
Or maybe that can be a key to geopolitical peace. Food. Well, thank you very much, Dana Elizabeth, Prid, HK45, Jade, and Dong for coordinating everything, and of course Cecilia for all these brilliant questions. And thank you to the audience as well. I think that's probably time to draw this to a close. The chat is
thank you
recorded.
very much. Thank you very much indeed. And I hope the typhoon isn't too serious.
Judging
Thank
by
you.
the window,
It hasn't really started raining. Thank you very much. We
Thank you
look
very
forward to meeting you in Hong Kong next time you come.
Thank you for your time.
Goodbye.
Bye-bye.
Thank you. Bye-bye. Bye all.